I have reviewed the file, all of the materials that are on file here. I have heard the argument and recommendation of the state and the argument and recommendation of the defense and the defendant's statement to the court as well. And I have reviewed the victim impact statements that are on file, the written ones. Also, what both Michael's mother and father spoke about to the PSI writer. And I've heard the statements today of the defendant's daughter and of Michael's mother. I've handled a number of devastating cases over my years in the criminal justice system. I think this is one of, if not the toughest one, because of the senseless and absolutely preventable death of an innocent 8-year-old boy who just wanted to hang out and have fun with an adult in his life whom he trusted. I can't imagine the pain of losing a child in any circumstances, but it's pretty unimaginable the way that this has happened to Michael and his family that is left behind. This did not have to happen. It was entirely preventable. Senseless. It's something that is incredibly hard to wrap one's head around. I have heard the recommendation of the district attorney's office. The district attorney is recommending 30 years of initial confinement and 15 years of extended supervision. The Department of Corrections through the PSI is recommending 18 to 22 years of initial confinement and a period of time of extended supervision after that. The defense is recommending 11 years of initial confinement and 5 years of extended supervision. The court has to look at what are its sentencing objectives with regard to this case. First of all, protection of the community is absolutely important here, and it's a priority. No one in their right mind would ever have thought that something like this would happen by this defendant to Michael. And yet it did because of choices that he made that night. The protection of the community is incredibly important here. Punishment is an objective of the court as well. It's one of the ways that human beings learn, is through punishment. Part of a deterrent. Deterrence of others, as noted by the state, is an important objective of this court as well. That the community sees that someone who chooses to act in this way with an utter disregard for the sanctity of human life and the trust that has been placed in them by an 8-year-old boy and his family, that there are consequences for actions. The court is torn as to whether or not an objective of its sentence today is rehabilitation of the defendant. Because the court shares the state's concerns, what is there here to be rehabilitated? This was a reckless choice that no one in their right mind would have ever thought would happen. How do you rehabilitate someone from making those kinds of choices? Someone who is a full-grown adult, 52 years old when this happened, with an education, a background having been trained as an EMT, having training in surgical technology, and having been through a concealed carry class with regard to firearm safety. What more is there to be rehabilitated that weren't already in his skill set to prevent this from happening again? Or is the objective of the court rehabilitation in terms of, as kind of mentioned by the defense here, counseling to help him live with what he has done? When I look at the crime here, and make no bones about it, this was a crime. First-degree reckless homicide. This wasn't an accident. This wasn't a mistake. I'm not sure if it was in the PSI or the defense memorandum. I think it was actually in both. The defendant referring to this as an accident, a freak accident. A freak accident is something that is not preventable. That is not what this is. This was entirely preventable. This was the result of reckless choices, a series of them. The defendant told police, and I'm getting this information from the PSI, Steven stated that he showed Michael the guns because it made him look cool. That's one of those things that it's impossible to wrap one's head around. A 52-year-old at 2 o'clock in the morning, roughly, pulling out firearms to look cool to an 8-year-old. I know that alcohol was involved, although there's no indication here that he was impaired to the point of intoxication. About an hour and a half, roughly, if my times are right, after the shooting, his blood alcohol level was a .02. He admitted to having 2 rum and coke drinks that night after Michael's grandmother left the house, so after 10 p.m. Sitting around playing video games with an 8-year-old, but you needed to drink? Maybe that's where the rehabilitative needs are. But there's no indication that you were intoxicated. The PSI goes on to state that you told police. He stated that he showed Michael a stun gun that he had at the residence and was, quote, popping it, end quote, and pointing it towards him while he was squirming away. A stun gun is still a weapon. How is that fun? The defendant then went to his bedroom, took out a 9mm handgun, and took the magazine out of the gun. He did not believe the gun would fire without the magazine in it. He reported he walked out of the bedroom, pointed the gun at Michael, and pulled the trigger, expecting it to click, but instead it went, quote, boom, end quote, shooting Michael. He stated that he was trying to be, quote, cool and exciting, end quote, for Michael. How is it cool and exciting to point a gun at an 8-year-old boy? Today's the first that the court learned that the bullet went in through Michael's upper arm or shoulder area, came out, then passed through his neck. That's a defensive posture. How is that fun and cool for Michael that you come out of a bedroom, pointing a gun at him to the point where he's scared. He puts up a defensive arm and you shoot him. How is that fun? How does that make you look cool? You were asked if you had ever taken a hunter's safety or concealed carry class, to which you said yes. When asked if you had ever pulled a weapon on anyone before in a joking manner, you said, quote, I might have done, strike that, quote, I might have before with Michael, but that would be with, you know, the gun I usually carry concealed, end quote. You then mimicked how you would do it before with Michael, with police. You mimicked drawing a pistol and pointing it toward the ground. You said you would do this to get them to listen fast. And when asked by officers if you thought that was a good idea, you said probably not. You told the PSI writer and this is different than what you told police. You told the PSI writer you asked Michael if he wanted to see the gun and learn more safety. One of the first things that's taught with gun safety is you never, ever point it at someone. You never goof around with guns. Yet you tell the PSI writer you wanted to show Michael gun safety. That's not what you did. Mikey said yes to wanting to know more about gun safety. So you unlocked your safe with the firearm. You removed the clip from the gun and went to show Mikey the gun. The gun fired, and you lowered the gun and saw a hole in Mikey's neck. And you admitted in your independent memorandum to the court that you pointed it at him and pulled the trigger. When they searched your residence, they found 268 rounds of ammunition in various sizes and brands. You had inside your home a shotgun, a full-sized 9mm handgun, and a Smith & Wesson handgun. Apparently, you also had that stun gun in the house. There are three primary sentencing factors that the court is to consider when weighing an appropriate sentence: the need to protect the public, the gravity of your offense, and your character and rehabilitative needs. Clearly, through the court's recitation of what happened that night, this is a serious offense. They don't get more serious, other than if this had been intentional. And there's no indication that it was. Not at all. It was reckless. But it was based on choices that you made. Again, the protection of the public is a paramount consideration of the court, and your character and rehabilitative needs. In weighing these factors, the court looks at a number of considerations. Your prior record. The prior record is listed in the PSI. It's been touched on by the state. Although you haven't had any criminal convictions in roughly 20-plus years, you do have priors before that. Everything from thefts to OWIs, domestic battery, There's that unlawful use of a weapon charge from 1994, which is concerning to the court. You've been on supervision before. I am to consider if you have a history of undesirable behavior